We are here once again with one of DC's premier probate and estate planning attorneys, Mr. Michael Forster. How you doing, sir?
I'm doing great. How are you, Cedric?
Fantastic. Thank you for asking, and thank you for taking the time. The So what you and I have been doing over the years has been really great. We've been able to work together and help a lot of people. I've sent lots of folks your way, and vice versa. We're helping to demystify this seemingly very complicated DC probate process for folks. And so videos like these, I think, are going to help people before they even speak to one of us to have a better understanding of what all of this stuff means and why they should talk to a professional. So in this video, we're going to talk about bond. Now, some people have probably heard of a bail bond, right? Uh, this is, in a legal context, bond is something that is required with a probate. Is that correct?
That is correct. It is it is required unless you have an exception. So everybody has to deal with it in some way.
Right.
So it can seem like a wonky, boring topic, but please don't turn off the video yet. I'll try to make it interesting. You see a bond and people's eyes glaze over, and it's one of those words and concepts that is boring, but it's necessary, and we'll try to keep it interesting. But yes, it's something that if you want to open an estate, if you want to get your inheritance, it's something that you're usually going to have to deal with.
Right. And so maybe when we put the video out, wherever it goes, maybe the title should be Bond. You're going to have to deal with it.
That's right. Not quite as catchy as Bond, James Bond, but it's well.
There you go. So it's not bail bond, it's not James Bond, but
right.
It's the bond that you will come to know. Okay.
Yes.
So I guess the first question would be, well, what exactly is bond in relation to a DC probate?
Yeah. So if you think of bond, just think of insurance. So imagine that you have to get an insurance policy to cover yourself. So bond is something the court requires, and when it requires is basically you're going to be, if you're going to apply to be personal representative, executor, if you're applying to be the executor of the estate, you're going to be entrusted with assets, the assets of the estate. You're going to have control over those assets. If there's a house, you're going to be able to sell, transfer, do anything you want with the house. But to make sure that the beneficiaries, the heirs of the estate, to make sure that you don't just run off and take the house in your name and keep all the money and go to Tahiti with it. It's a form of insurance that for that scenario. So if there's a bond, you run off the money, you do something illegal, the heir can make a claim against the bond, and the insurance company will basically pay them for what was lost by your malfeasance. So I've never had that happen. I don't want to have that happen. I don't want it to need to be used, but it's just a form of insurance to protect the heirs based on what the personal representative has control over.
Okay. And so in that way, it is somewhat similar to the bond for when somebody is trying to get themselves out of a jam, because if they abscond, then the court is going to take whatever was put up as bond there. So there's still the element of protection against somebody doing something that they shouldn't do.
Right, exactly. So in the bail bond scenario, yeah, it's insurance so that the person doesn't run off to Mexico or wherever.
Yep.
And you're putting up something as collateral. This is something similar. You're paying an annual premium. You're paying like an insurance premium every year the estate is opened to cover that insurance for the benefit of others.
Okay. And I don't recall, but I think, a bail bond, maybe like 10% or something like that. How much is bond in the probate landscape?
It depends on the value of the estate, and it depends on if you get bond waivers, how many heirs there are, that type of thing. In my most estates that I handle, the bond costs between 1,200 and 2,000 or 3,000 per year for the premium. This is an estate expense though, so it's due after you're appointed. So if there's money in the estate, you can pay it from the estate. So it's not something that you have to just pay out of pocket for, assuming you have access to money. The tricky ones are when there's a house and no money and you have to pay a bond, but there's no money to pay the bond. So you either have to come up with it yourself, have an attorney to front it for you. I do that sometimes if there really is no money and that kind of thing. But yeah, it varies, and it'll be a one-time expense if you finish the estate in a year. If you go beyond a year, you'll have to pay it again until the estate is closed. So
Wow.
yeah, so but it definitely, it just depends on how big the estate is.
And that's going to be a year from when it was open, not like a calendar year, correct?
Right. So the clock starts. So you get appointed. Say you get appointed in October. They'll send you a bill that's due in a month, and then the next year you're going to have to pay by October for the following year.
Okay, so you can start one on January 2nd, and then the next one will be due on January 2nd if you don't finish.
Right.
It. Okay, that's good to hear. And I heard something that speaks to just how amazing you are. And folks, don't take advantage of this when you talk to Michael. You have put the bond up for folks from time to time in some rare circumstances. Did I hear you say that correct?
Yeah. If they don't, I work with some, lower income clients who don't have the money for it, and they have an asset, they have a house that they're going to sell. I'll sometimes pay the premium, to be reimbursed when we sell the house. I've done that before, and I will do that. If my clients have the money to do it, I have them do it. But if I have some circumstances where it really is, they have a valuable house, but they don't have liquid cash, and I want to keep the process going, so I'll do that.
Yeah, see, and this is why he's one of the premier attorneys in the area. Not only is he good at what he does, he's also a good human being. A lot of these attorneys will not do that. These big firms will not do that for you. Just saying.
Anyway.
Oh,
thank you. I try. Every time I wake up and I say, how can I be a good human being today? So
yeah, you've been very successful thus far, my friend.
yes.
Okay, so you've told me what it is. You've told us why we need it. Now, because there's money that has to be put up before you even really do anything. Well, a couple questions here. So one, is this something that applies to small and large estates?
So it applies to all. So first of all, before I answer that, when it doesn't apply. So if you're the only heir of the estate, you don't have to deal with it, because you'd be protecting yourself from stealing from yourself. So that doesn't come up. You can also, if there's a will that waives bond and the will is a valid will, that also does not require a bond. And if you get bond waivers from every single heir, then you don't need a bond either. If you get bond waivers from some heirs, then your bond can be less than what it would be. So if it's someone with that, there's no will that waives bond, you want to get as many bond waivers as you can. So those are, I wanted to make sure I communicated that part too. So there are some cases where we don't need bond, and I always prefer those situations because you don't have to do it. So yes, but yeah, you need it. You need bond to cover whatever the value of the estate, no matter what the estate is, unless it's one of those exceptions.
Okay, no, that's good to know. So if it's just you don't need it. If you get a waiver, if it's something in the will, you don't need it. Okay, so there's a lot of ways that you can avoid needing the bond. But outside of that, any way you slice it, everybody is going to need to know what bond is. They need to watch this video so that they can already be prepped and ready, because it's going to come up in the conversation, and be able to figure out how it applies to their particular situation. Okay.
Yeah, and the worst scenarios are when so you have to qualify for it. So when I say qualify, it's not quite like qualifying for a mortgage, but it's somewhat similar in that they take your social security number. There's a bond company I work with all the time. They take your social security number, they run like a soft credit check, they look at your assets and your income, and they decide whether or not that they're going to give you this insurance, this bond to cover the estate. And they sometimes, there's a certain credit score number where they won't give it to you at all, and you can't get the bond, and you can't serve as personal representative if you need a bond and you can't get it. So that is something that comes up, and it's really hard situation where it's like someone is entitled to be the personal representative. They're the child of the deceased, that's their husband or their wife, and they can't serve because they can't qualify for the bond. So that has happened.
So you're telling me you have the money. People have said, we understand that this is something that needs to be done. Everybody's on board. You go to the bond company and there's a chance that they could say no.
Yes, it's happened. It's happened before. And so then in that situation, maybe there's a different family member with a better credit score. Sometimes I agree to be personal representative on their behalf because I can qualify for a bond. I've qualified before. But otherwise, yeah, you're out of luck. So it's it can happen, and not everybody is aware of that, and it can be frustrating. But yeah, it's just the reality of the situation.
Now, the bond is something that is tied to the personal representative. Is that correct?
So yeah, because the bond company, it's like a bail bondsman or whatever, they're going to look at this person, or a bank, mortgage company, they're going to look at this person and say, do we trust this person with the assets of the estate? Do we think that they're a trustworthy individual who's good, and if someone who has bad credit, has a bunch of bankruptcies or foreclosures or things, they might look at that person and say, we don't trust you with the bond. And we're not going to give it to you. So they're going to look at the holistic picture of your situation. And they might say no. I mean, if you own a house, that's something that's helpful. If you have a higher income, that's something that's helpful. Certainly your credit score is most important. So, reason number 500 why you want to work on your credit score and make sure you have a good one, if you can, because there's a certain level that they've told me you have to be at to be bondable, is what they say. So yeah.
Okay. Yeah, and listen, let's just be honest. If you haven't heard the term before, I use this a lot. Credit score, your credit report, that's your adult report card. So basically, they're looking at this thing saying, how has this person been doing as an adult? And they're making a judgment based on that as to whether or not they can trust you. That's really all of the credit pulls, and looking at your credit report, the scores and everything. It is a risk-based assessment on your worthiness as a risk. There's this company that you don't get to talk to that is saying, who is John Smith? Based on this document, can I trust John Smith? Is John Smith going to uphold his obligations? And based on that, they'll decide whether or not they will entrust you. Because if they make a bad judgment with this bond document specifically, well, you run off and then they lose a lot of money, right?
Right. They want somebody who can handle their financial affairs and be responsible.
That's the key.
So,
yeah.
So yeah, I know different things can go into credit scores that might not be your fault. That might be, situations outside your control. But for what you can control, and I know also the credit score system isn't perfect and might have biases and things in it, but that's just the reality of what we have to deal with. So whatever you can do to address issues that might be hurting your credit score or establish more credit and pay things on time, you can help yourself there. So
I think that's well said. And obviously, with this video being shot in 2022, we understand that there have been a myriad of circumstances that have occurred after 2020 that have had an impact on people and subsequently impacted some of their credit profiles. So we're sensitive to that, but we also understand that within this system, these companies, they have this certain criteria, and they're going to use that adult report card, that credit report, and that score to make that judgment, because you don't get to have a conversation with them and, tell them and explain all of the intricacies of your situation, unfortunately.
No, yeah, that's exactly right.
Yeah. Okay. So just out of curiosity, where does the bond fall into the probate process?
It's throughout. So you need the bond to file the petition. If it's a case where you need bond, it needs to be ready before you file it. Otherwise, the court will reject it. And it needs to be in place until you close the estate.
Oh, so that's pretty early. And then it stays until you close. Okay, I got you.
For as long as you have control over assets, it needs to be there.
Got it. Okay, so this comes up pretty early. All right, so this is
Yeah.
really something that when folks begin the probate process, they need to be watching this video so that they can know what lies ahead.
That's right. That's right.
Okay, very good. All right, well, I feel like we covered it to a significant degree. What do you think?
I think we did. I don't know if I was successful in making it interesting enough for people to still be watching at however long into the video we're in, but I hope so. Yeah, I think that covers everything so that I can think of. Certainly the more intricacies and things that I've done, but as far as a summary, I think we covered everything.
Okay, well, folks, that's bond. Everything you need to know about it and a little bit more. So to find out where you are in the process and what bond might look like for you, to get questions about who these companies are, what the credit scores are, and how to navigate all this kind of stuff, you should talk to Michael Forster. So how can they reach you, sir?
They can go to my website, forsterlawfirm.com. It has all my contact information. You can email me at michael@forsterlawfirm.com, and Forster is Forster, no middle E, and it's not Foster. And my phone number is 202-400-2489. Everyone's always misspelling my name, so I'm not offended, but I don't want you to send me an email to Michael Foster or Michael Forester and it go to somebody else. So that's why I make that correction. We don't all have names like Stewart that everybody can spell. Although I'm sure someone has misspelled Stewart over the years. I guess it's a UART.
Absolutely. Those UARTs, you get this ridiculous, no offense, Cedric with a K. That happens way more often than it should. There are not a lot of Cedrics with a K out here. And the STEW, I feel, I'm biased obviously, is the more common spelling, but for Esther, that's funny.
Yes, Finding Forrester, I think that movie set me back 10 years. And Forrest Gump as well. People just want to put that E in there. I need a Forrester movie, but none's come out yet, so maybe I need to make it. But
okay, there you go. That's it. Well, listen, man, always great, highly informative. Really appreciate it, man, and looking forward to the next one.
Thanks. Appreciate the time. You have a good one.
You too.
Smash the like button and retweet and subscribe.